Coming, we'll go ahead and get started. This is the last of our Student Scholars presentations this year. The series was instituted about 8 years ago, exactly 8 years ago, in order to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference-style setting. Today's presentation will be made by second-year student Debbie Chu. Before I introduce Debbie, I'd like to first introduce the respondent to her presentation, Professor Suzanna Fisher. Everybody knows, but you didn't maybe know these things. She received her legal education at Merton College, University of Oxford, where she received a BA in jurisprudence, and the University of Virginia School of Law, where she was awarded the LLM degree. She also studied at Princeton University, where she earned an AB in history, magna cum laude. She practiced for 5 years as a barrister in London, England, taught contracts at London Guildhall University, and spent 3 years practicing intellectual property law in New York City with both Skadden Arps and Paul Hastings, Janofsky, and Walker. She joined the faculty in 1999, where she taught copyright law, art law, entertainment law, introduction to intellectual property law, international intellectual property law, constitutional law, comparative constitutional law, and civil procedure. We thank her for being here today. And now let me introduce today's student scholar. Debbie attended the College of Holy Cross in Worcester, Massachusetts, where she double majored in classics and philosophy. She came to law school to study intellectual property, an interest that stems from the Napster lawsuit in the late 1990s, in which the Recording Industry Association of America, the RIAA, sued Napster for copyright violations. Having a strong interest in music, Debbie wanted to use her legal education to help protect the property rights of songwriters. The article that forms the basis of the presentation today was written for her entertainment law class, taught by Professor Fisher, who recommended the article for the series competition. So now I'll turn the floor over to Debbie Chu for her presentation, the title of which is, as you can see, The Future of the Copyright Compulsory License of Copyright Law. TikTok, it's time to eliminate it. Debbie.
Well, thanks to Professor Harmon for giving the introductory remarks, and thank you, Professor Fisher, for nominating my paper and being my respondent today. And finally, thank you all for showing up today. As you can see from this slide, my topic today is called The Future of Compulsory Licensing in Copyright Law, TikTok, and it's time to eliminate it. So compulsory licenses, you probably have never really heard of it. It's a very complicated and confusing topic. And today my goal is to help all of you understand the basics of it and maybe, hopefully, feel passionate about the subject. Okay, so there are multiple compulsory licenses, but I would like to say that my presentation is only focused on the Section 115 compulsory license of the Copyright Act. Without further ado, I will go ahead and play 2 songs to help you understand what a compulsory license is. Now you have a rough idea of what that song is. Later on, after I play the second song, I'm going to ask you who sang the song. Okay, so here goes version 2. Okay, so can anyone tell me who wrote the first song and or the second song? Yes, excellent. So who wrote the second one? Sorry, was that? Oh, okay, you don't know. All right, well, the second song was written by Quiet Drive. It's an alternative rock band. So as you can see, like the two songs are quite similar. They have the same lyrics, but the melody is obviously different. So Cyndi Lauper wrote this song in 1979, and it was like one of the best songs that she's ever written, and music critics have said that it was her masterpiece at the time, and it was also her #1 hit on the charts. And then in 2006, Quiet Drive wrote the second song, also titled Time After Time, and this song actually appeared on Top American 40 Countdown. It was ranked #25, and it was also in the movie John Tucker Must Die. So, you now know that the two songs are pretty similar with each other, and who thinks it's fair that Quiet Drive had used Cyndi Lauper's version and gained all this recognition? Can I have a show of hands? Okay, so today's presentation, I'm going to try to convince all of you who did not raise your hands to hopefully do raise your hands after my presentation, because I argue that it is unfair. It's unfair to Cyndi Lauper because Cyndi Lauper was the one who came up with the song, and Quiet Drive took the song and altered it in their own way without changing much of the lyrics. You know, like they did not do much to the song, but here it is, like they gained all this recognition. So yeah, I will go ahead and talk about how that is legal in copyright, because as you know, copyright grants the exclusive right to copyright owners, but here you would think that it's kind of illegal for Quiet Drive to be taking Cyndi Lauper's song and making it into their own song. But here's where the compulsory license comes into play. Section 115 says that anyone can take the original song and make it into their own song without making a fundamental change to it. And let us look at the relevant language of the statute. This is section 115 of the Copyright Act. I've also bolded the relevant language. So it says, when phono records of a non-dramatic musical work has been distributed to the public in the United States, any other person may, by complying with the provisions of this section, obtain a compulsory license to make and distribute phono records of the work. So now you may be wondering what phono records are. Phono records, some examples, and I'm sure like all of you know this, like DVDs, music files, MP3s, they're all examples of phono records. But the copyright definition of that, they're material objects in which sounds are fixed. Now, you may also have a question on what the meaning of fixed is. Fixed, for something to be fixed, it has to be perceived, reproduced, or otherwise communicated. So if you want to fix a song, you can write a song on a piece of paper, and that's fixed. The piece of paper becomes the medium. So that's the definition of fixation. Okay, so in sum, this license lets people do all of that. It lets people take an original song and transform it into their own song. And even without the copyright's owner permission, they can do this. All they have to do is to comply with the provisions of the Statutory Act, as well as paying the royalty fees, which I will address that later on in my presentation. But just to make clear, when you hear a recording of a song, there are two separate copyright protections. One is the sound recording, which is a different copyright I will not be talking about in this presentation. But the one that I will be talking is the copyright law that protects the song itself, and that protects the lyrics and the melody of the song. So the compulsory license, to sum things up, protects the lyrics of the song, but not the recording of the song. So to give you a little bit of background information, why was the compulsory license created in the first place? It was first created because they feared of a potential monopoly back then. So in the landmark Supreme Court case called Whitesmith Music Publishing Company versus Apollo Company, it decided that Whitesmith's copyrighted music was not an infringement because the piano rolls at the time, which are shown here, they were not classified as copies of a copyrighted sheet music. And basically, because they were not an infringement, the rolls were not part of the machine that reproduced, the rolls were parts of the machine that reproduced the music, but so the manufacturers of these rolls were not required to pay the royalties to the music composers. And so after this ruling, Congress had subsequently incorporated the copyright owner's right to record and mechanically reproduce these musical compositions. At the time, Aeolian Company, which is the largest manufacturer of the time of player pianos, feared that they would overturn this case. And so what they did was they contracted with all the leading music publishers at the time for their exclusive right to record all their music. And then that was when Congress had to create the first compulsory license in response to all of that. And I have a little sad face because they're scared. They're scared that Aeolian would basically overtake the music industry at the time. So there are two opposing parties, and I think it's important to distinguish the two of them. The songwriters and music publishers are the copyright owners in this, and they obviously want to do away with this license because it's unfair to them. And then the second party is the recording companies, and they're all for it. You know, they're like, let's keep the compulsory license because we've had it forever, and to do away with it would cause chaos. The songwriters want to they want to do away with the license because it's unfair. They could be earning more money for what they're doing, but they're really not because there's a fixed statutory rate, which I will discuss later on. So here's a little roadmap of my argument. Reasons for eliminating the license. So the license was created solely for the purpose of a potential monopoly. But in today's world, there's no monopoly anymore. It is also unfair to copyright owners. It also has very vague statutory language. And then amending the license won't help at all. Okay, so to visit the first point, there is no monopoly. The Recording Industry Association of America, also known as the RIAA, represents over 1,600 member labels. As opposed to back then in 1901, there was only one dominant manufacturer, which was the Aeolian Company. And also, record labels may become obsolete. So as you all know, Macklemore's Thrift Shop song, he did not use a record label. All he used was YouTube to get famous, and this song was ranked #1 back in 2013. And so with the internet and all the technology we have nowadays, record labels may become obsolete. But regardless of whether they become obsolete or not, we should still say that it's not justified. The compulsory license does not allow copyright owners to negotiate for a higher fee for their music. So the next point is, I've been referring to this early on, it's unfair to copyright owners because right now there is something called the Copyright Royalty Board, and it has 3 copyright judges who decide the statutory rate of these songs. And this was actually decided, this rate was decided in 2006. Basically, it says you can pay the larger of 9.1 cents per song or 1.75 cents per minute. And as you know, things have changed in the past 10 years. The economy is different, there's inflation now, and yet we still have this current rate. And the next point is that this rate, it imposes a price ceiling. So when people pay this royalty rate, it's almost practically impossible for copyright owners to be negotiating for a higher fee. People could go to something called the Harry Fox Agency, and that's a private agency that allows the two parties to negotiate. But in theory, why would you want to be paying something that's higher? You want to be paying the statutory rate. So it's almost practically impossible to be earning more money from this. And then the next point is that the statutory language is very vague. So all it requires is that the new cover song does not change the basic melody or fundamental character of the work. But what is that? Like, what constitutes as fundamental character? There is no legislative history on it, and all it says is that you just cannot alter it to make it sound really different. So that, in essence, is also really unfair to copyright owners, because you can change it whatever way, as long as you have the same lyrics and the basic melody, then you're all set. You can claim that as your song. And then amending the license won't help at all. There have been a lot of recent proposals in the past, such as the Section 115 Reform Act of 2006, and that is also known as SIRA to most people, S-I-R-A. Their main purpose was to create a blanket license, and a blanket license while retaining the rest of the compulsory license, retaining the rest of the Compulsory License Act. Their purpose was to clear all of their rights they need to make large numbers of musical works quickly. So for Pandora, for Spotify, you know, like they don't have to go individually to copyright owners to do all of this. All they have to do is just like, it's all the rights are cleared. So people think that this was a fundamental reform act, but unfortunately it was never enacted. And then the second proposal was that there would be an express audit right. So as things stand right now, there is no such right in the license, and it just uses an honor system to self-report without requiring any verification. And so songwriters must rely upon user-friendly, user-certified royalty statements. And so if there are multiple owners, a licensee may pay all royalties to one co-owner without paying others or notifying others. But as you can see, all these proposals, I've just listed two of them, they don't really justify why we have a license. You know, like they don't talk about increasing the statutory rate. How can you depend on 3 judges to make this decision when a lot of things have changed? Music streaming, the economy, and all of that. So to recap, there is no monopoly anymore. And the second thing is it's unfair to copyright owners. And another thing I would like to add to that is, I'm not sure of how many of you are familiar with Spotify, with how Taylor Swift had removed all her music from Spotify because she thought it was unfair that songwriters were not getting enough of their money for that. And just to give you an example, if you purchase a song on iTunes, it's $1.29 to download a song. But approximately 80 cents is allocated for the sound recording, and only 9.1 cents goes to the musical work. So you can see that there's a huge discrepancy and people aren't getting enough for what they're doing. And then the third point is the vague statutory language, that there has to be no fundamental change, and then all you have to do is just, you make your own song, and then you can claim that song to be yours. And then lastly, amending the license won't help. So what is my recommendation? My recommendation is to phase out the compulsory license over a period of time. I'm not sure how long that will take, but it will probably take a couple of years. It's basically impractical just to do it away in a few days because it's been with our music industry for such a long time. And that concludes my presentation.
And now, Mr. Fisher, if you will.
Oh, sure. Well, thanks, Debbie. You're welcome to sit down if you'd rather, if you're more comfortable.
You can't, she has to stand right there.
Oh, okay, all right. So I think Debbie's work is in a really important area and really cutting-edge area of copyright law right now. I think everyone agrees that copyright licensing needs some pretty major reforms in general, and the Copyright Office has recently taken it upon itself to study this issue and has issued a 245-page report just with a few preliminary thoughts on music licensing. So if you guys find this area confusing, there's a good reason why. And Debbie really could only, in a brief talk like this, scratch the surface of a lot of the issues that are involved here. She was talking about one piece, tiny piece of the music licensing puzzle, and that's where, she explained it really well. Someone wants to record a musical work, and that's only a song, but we also have copyright rights in the recorded version of the song that where we're essentially rewarding creativity in production and in performances. And so for every piece of music that's recorded, we have to worry about getting rights in two different kinds of music copyrights. And the mechanical license is only one piece. So we're dealing with a very fragmented licensing system in a way out of necessity because we have these two different music copyrights. And then the industry has developed to have numerous intermediary players who are involved. And one of them, Debbie mentioned, the Harry Fox Agency, that essentially handles most of the mechanical licensing in this country. But as she also correctly says, not just because you're dealing with another entity doesn't mean that you're outside of the statutory limits on the mechanical license. The rates are essentially constrained by the statutory license rates, and so there's a ceiling there. And that's really where the dispute comes from for mechanical licenses, in saying that there's a statutorily set rate. Is it unfair to songwriters, basically? Is it too low? But there's some other issues that relate to that even add to that problem, where you have to renegotiate the statutory rate every 5 years. And so the Copyright Royalty Board, this panel of judges, is just about to do that for the period 2018 to 2022. It leads to enormous battles, which are very expensive and very time-consuming. And there are numerous compulsory licenses, not just the mechanical license, that have to constantly be renegotiated. They're also dealing with a public broadcasting license going forward. But because you've developed this very complex industry with a lot of intermediary players who essentially administer the licenses, once the rates are set, and then you have these rate-setting bodies, you have a lot more players involved than just the songwriters and the users of music. You now have to worry about all these intermediary entities, and then you have to worry about the two music copyrights, and then you have to worry about a multiplicity of copyright rights. The mechanical license only deals with one copyright right, which is the right of reproduction. And it was set up, as Debbie correctly said, at a time of piano rolls technology. Well, we've moved on to digital technology. Our basic copyright statute comes from the 1970s, when digital technologies were not something that were widely used, or used at all, really, for the distribution of music. I guess you guys out there, how many of you listen to music almost predominantly via streaming? That would be, things like where you're not actually you're not downloading digital copies that you own, but you're just streaming music over the internet and listening to that, like radio or Spotify, Pandora, where you're not making choices. I mean, I listen to music that way, predominantly. How many people listen to music predominantly that would be digital downloads, like maybe iTunes, where you have your own copies of music, but you're listening to digital copies? So a few of you do that. How many of you listen to CDs or, okay? Going back in time, yeah. How many listen to LPs? How many people listen to piano rolls? No, I'm just kidding.
Okay, I'm out.
All right. We don't go back that far. But the point is, we pretty much moved into a landscape where we're increasingly moving into a streaming landscape. And it's probably going to be interactive streaming, where people don't even necessarily buy their own copies and store their own copies, but essentially download like cloud-based services and so on. And so we're dealing with a licensing system that was never set up for that because it implicates too many rights. In that doesn't only implicate necessarily a reproduction right, but also a performance right that the mechanical license doesn't even cover. And so we have a big problem with these fragmented licenses because you have to figure out what right is implicated and where do you go. And because of the nature of these rights coming together, rights that used to be separate, you now may need to go to two different entities and have separate licenses for something where you only needed one license before. So one possibility, Debbie's remedy of moving towards a market-based system to make the rates fair, makes sense on a lot of levels. That's one way that you just abolish one of these licenses. Although going forward, I think that she would have to think about what would happen to some of the other licenses that might be involved, like the public performance licenses that apply to sound recordings and would be implicated by some of the digital streaming. And so that's one issue that we have is how, when we're considering these licenses, we sometimes need to think about them as an entity. Another really big issue would be, going forward, how are people supposed to make contact with the owners of the rights? And that's a problem that we have now and that we would continue to have even after the abolition of, if we were to abolish the mechanical license. Because even though we have a situation, a landscape where there are major music publishers, there are really 3 major music publishers, there are a lot of independent publishers as well. And how are we going to know where to go? In the past, we could probably go to Harry Fox Agents. Harry Fox Agency might be a place that we could still use. They do have a database. But we need, going forward, pretty clearly to be developing some better repositories, probably online digital databases of ownership information. The Copyright Office is not equipped to give us that information, and so somebody is going to have to, probably the government, in my mind, the best system would be the government to delegate a private body to do this, to build up these databases so that you can essentially go online and fairly easily enter into some sort of negotiation, if you follow Debbie's model, to license rights cheaply, easily, and conveniently. But right now, we just absolutely are nowhere near being able to do that. In England, they're beginning to develop this through something called the Copyright Hub, which is, again, partially government-funded, partially private body that's trying to build up a database like this. And I think it's really interesting what they're doing there. And right now, we're not really doing this. The Copyright Office sort of pointed out it's a problem, but it's way beyond their abilities to deal with it. I'm not in no way blaming them. They just simply do not have the resources to do that. But we need to think about that as well going forward. And to me, that seems like one of the most pressing issues, almost regardless of what we decide to do over whether these licenses are still essentially statutory rates or completely voluntarily negotiated rates. Because people, want to be able to do these without major transaction costs. And then the third issue, I guess, would be sort of what happens to all of these intermediary entities that are currently involved in this multiplicity of licenses, Harry Fox Agency being one of them. What is their role? Do we just remove them? If so, that might lead to a certain amount of industry chaos. But if not, what is their role going to be going forward? And everybody has an interest in this because it's ultimately going to affect the prices at which music can be obtained, whether you obtain it online or whether you obtain it and listen to, recorded music that you own yourself. This is terribly important for users, and it's something that has unfortunately become extremely convoluted and complicated, so it's very hard to reform. So I think Debbie is working on something that's really significant and important, to the ordinary person, because virtually everybody enjoys listening to music or other kinds of recorded works like online books and so on. And so it's important for us also to have choices and be informed consumers thinking about how this is going to develop. So I guess we could open the floor to some questions for Debbie or comments. And I'd just like to say how happy I am that she's, there's so many people who are interested in this area.
Sylvia?
So if I wanted to use a song like Get Knocked Down or something like that to make it something like that's mine, how do I go about getting the statutory?
Okay, so if you know the copyright owner of the song Knockdown, then you can locate the copyright owner and then serve something called a notice of intention to obtain a compulsory license. And all you have to do is just make your royalty payments every time you make and deliver a phono record. But let's say if you don't know who the copyright owner is, then you go to the Copyright Office, and the Copyright Office will do its best to seek the copyright owner of the song. So.
I mean, that was the point I was making about how difficult it can be to find the owner, because there is no one place where you can definitively go and know who has the owner of rights, because the Copyright Office is not required. They may record the initial owner of copyright, but for music copyrights, there often is a chain of title. And it's not required that you record in the Copyright Office every transaction. Recordation is optional in most cases. So you often have no idea where the rights have been assigned and who holds them now and how to get in touch with them and how to reach them. And that's a huge problem, leading to a body of works that we call orphan works, where we really have no possible way of identifying who the owner is. And then we put users to a terrible bind. Do they just assume that the owner will never be tracked down and therefore doesn't care? Or do you take the risk and then the owner pops up and says, oh, sorry, I'm the owner, I'm suing you now, for statutory damages that can be $150,000 per work. It can add up.
Yes, Professor Breeder?
I'm a question maybe for either of you, but then it's based on a complete ignorance of what's going on here. You get rid of this statute, of this compulsory license. I write a song, I like trouble. Now, it seems
Very hypothetical, I hope.
I go with the flow. I think I have to say, it has nothing to do with A.G. Harmon's I like height, so I don't pay any, it's not there's no copyright connection. Or it's the Wild West, for who I have to negotiate a separate. So isn't that going to be like chaos? Litigation, if I say it's a completely fundamentally different work, then there's going to be litigation on that. And if I say, well, okay, I'll pay a license to I like Ike, I'll pay money to get a license to I like Ike, it'll be like a Wild West negotiation. Unless, I suppose, if the Harry Fox Agency and some others take over in a market sense the whole function. So that's, my question is, are we creating maximum litigation possibilities by this? I have a narrow second question, which is maybe just information. To change fundamental character, is that a melody and style issue, or is that like a substance issue? Could I take a gospel song and turn it into a satanic song? No, is that fundamental character if it's the substance?
Well, to address your second question, if you have the same lyrics, right? Like, let's say you have the same.
Well, I substitute Satan for.
That way.
I don't think you could do that. You really need to stick to the
That would
existing
change
lyrics.
Yeah, because you would need the same lyrics, but you can change the basic melody of the song. And like, let's say your satanic version is more fast-paced or something,
Well, upbeat.
or upbeat, like, so the original version, if it's more, slow-paced,
You
you
can change
can.
the style and arrangement of the work, but not so much the fundamental notes or lyrics of the
Right.
song. Now, you also have a wide range, if it were a parody, the Supreme Court has very enormously protected parodies.
I like trumpets down.
Okay.
So that's something called a derivative work, which is not covered by the compulsory license. Because another example of derivative works are like, if like they're different renditions of Cinderella, the one that was Hilary Duff was in, and then like the Disney version. So that would be a derivative work, but that's not covered by.
But what about my first question?
The Wild West question.
The Wild West.
Okay. Did you want to?
What about
Well, I mean, so your first question is that if
First, he was saying like the first thing is that he's gonna, what did he say? I don't know.
I like Trump. There's no complete life situation. So either I have to say, this is a new song, it's fun on camera.
You'd fight with that guy.
I like Ike, and then
He said, no, it's just my mind.
Or I have to enter into a kind of open negotiation.
You're gonna get held up everywhere.
And then there'll be lawsuits about that.
Well-
So there's an invitation of reconciliation.
Okay, but you want to do a song that you want to use AJ's original song?
Yes.
Well, I took it, I made it.
He did something
I
to
did the
it,
thing to it.
kept the lyrics,
Okay, so you would, I mean, under the current version, under the current situation, you probably would be outside of the compulsory license rule we just said.
Okay.
But we're assuming that if you're not changing it very much, so you're within the compulsory license, but you can't obtain a compulsory license at the statutory rate, then you would need to negotiate with AG, the owner of music copyright, and you would need to do that now if you were outside of the compulsory license. So we have a realm of things where AG can simply say, I don't, I think that based on previous works by Marshall Brager, I absolutely will never allow him to use any of my songs. So AG can simply refuse. That doesn't exactly lead to, it might lead to litigation if you then use the song anyway, because you would be infringing copyright maybe in the song depending on what you're doing with it. Maybe you then say, this is, some kind of fair use or something. But if we then take away the compulsory license, so it doesn't exist at all, and everybody has to negotiate a rate for every mechanical license, where everyone, that is, who wants to use a pre-existing song to, in a recording, that you're making a recording using somebody else's song, like a cover. And if we do what Debbie is advocating, where we take away any statutory license where the statutory license forces AG to license his song to anyone. AG no longer has any choice over who he licenses the song to. And it also forces AG to license the song at a rate that's set essentially by the Copyright Royalty Board judges every 5 years under statute. So there's a ceiling on that rate. that, is set, and that nobody, I mean, in theory, yes, you could pay AG more than the statutory rate, but why would you ever do that? There wouldn't, unless, there wouldn't really be much reason to do that. So if you take away the statutory license, then you're moving towards, you're giving AG the ability to have better control of his songs, because he doesn't have to license them to people that he doesn't feel like licensing them to. So if there's a risk that you're a Satanist and AG doesn't want to license to a Satanist, then he doesn't have to. So I think maybe it leads more, however, to essentially maybe market failures or difficulties like that, where you guys can't agree on some kind of rate, so that you're not able to use the song, and or you can't. AG is charging a rate that you refuse to pay, or that is unreasonable for you to pay, and so some would say, that may lead to many songs not being able to be used to generate future creativity, because of the stifle future creativity because of the difficulty in negotiating these licenses. But songwriters are complaining, saying, well, the statutory rates aren't fair. But that's not necessarily an argument against the existence of a compulsory license, because you could also come up with a different system for setting the rates than what we have now. And it was a very convoluted answer to your question, but I hope it answered it, sort of.
Cliff has a question.
Yeah.
Which you can't see.
It's along sort of the same lines. All right, so Taylor Swift records, "We are never ever getting back together," and then somebody does a parody, the lyric of which is, "We were never ever together in the first place." There was something like that. I don't know whether that was just something that was on YouTube and not being sold. Could I write such a response, quote unquote, to her song, using the same melody, using basically the same lyric pattern, without her permission, and would that be new work, or would that be something that at least I'd have to pay the 9.1 cents per copy?
That's a
That would be
parody.
a parody, which would fall under derivative works, which would not be covered under the compulsory license.
So that means she could sue me, or that means she couldn't even get the 9.1 cents?
That means you don't even need a license.
Yeah,
Okay,
that's
so-
your own work.
So basically,
So-
I can basically parody her work and sell
Yeah.
it, and she is not.
So basically, for something to be copyrighted, there are two requirements. One is originality, and the originality requirement is a very, very minimal requirement. There just has to be a modicum of creativity. So yeah, like even though you take kind of like the basic idea, but you change it up in your own way, that's still copyrightable. And the second requirement was fixation, which I just talked about. So yes.
Yeah, so the classic parody case that the Supreme Court decided was Two Live Crew. They're doing their version of Roy Orbison's Pretty Women song. And obviously, I doubt Roy Orbison loved the Two Live Crew version of his song, which did change lyrics, and they got in trouble on that album, for obscenity as well. But that was found by the Supreme Court, very, very First Amendment friendly approach. It's a parody. You need to refer to the heart of the work in order that people understand that it's really a parody. And there's no way of doing that without repeating the lyrics, the notes, the melody of the song, so it's completely protected. So you're totally outside of the realm of licensing there. What the
Sampling
yeah.
fall in with all that, or is that kind of weird?
Sampling is not governed by the compulsory license. There are papers written with regard to that. So if you don't know what sampling, so if you take up a song, you take like portions of it and make it into your own song. So I'm a huge fan of, like trance music. So like if you know Coldplay's version of the Sky Full of Stars. There's another version of that, but they change up the beats of the song. But that's not governed by the compulsory license, because that's sampling.
So sampling could be that you're either sampling, normally with sampling, you're sampling recorded music.
Right.
And so then you're getting into the realm of having two copyright licensing problems, both the musical work and the sound recording.
Right.
And the sound recording is governed by different licensing regime currently than the musical work. And the courts have been really hostile to sampling as fair use. So there's a number of cases in which courts have used biblical language, saying sampling, is like violating one of the 10 Commandments. Thou shalt not steal. Sampling is stealing. And it's interesting because I think this is a generational thing, that possibly these judges are just not really appreciative of the kind of music that uses sampling. But it does mean that, while you're dealing with these courts, you will need to license samples. And that has caused big changes to how recording companies, for example, go about dealing, with rights gathering. They're worried about sampling, and they do, make people get licenses now, which they didn't for a while before all these court cases came down. But there you're dealing not just with the, like Debbie says, that wouldn't be covered by a compulsory license. Because you're not using the entirety of the song in the same way. And then for the sound recording, you'd have to get a separate permission for that as well. A lot of time people forget about the sound recording, and to their detriment, I think. So that raises other issues that even, you now need to negotiate with two people who you can't find. So it's really a mess.
So the biggest problem is just not being able to find everybody to negotiate with.
One of the problems is you can't find them, and then the other problem is the rate setting. How do you set those rates in a way that's fair
So
to
once
all
you
the
find
different
them,
parties?
how,
And then thirdly, what's the role of these third-party organizations in administering these licenses and in making sure that the royalties are paid out to the right people, and tracking down these uses? Now, for sound recordings, there's also sort of a stable of different kinds of licenses, which include some compulsory licenses for non-interactive services. It's only a digital public performance right that they put in to try to deal with that. So you are dealing also with the compulsory license there. And so there's another rate-setting regime that applies to that, which is why this whole area is extremely fragmented. So it's hard because you're now also going to different bodies. You go to a body that's run by the RIAA called Sound Exchange to get those digital performance rights.
You might be thinking something else now. We're talking about music and all.
Yeah.
Let's say somebody wants to remake a movie. They want to remake a movie. Because I was just seeing this on like the old movie network. These boys down in Mississippi, they, like in the 80s, they got to be big fans of Raiders of the Lost Ark. And every summer, they remade Raiders of the Lost Ark, like 7 years. Bootleg copies of the thing got out. It became like this cult thing to see Raiders the remake. It's now in Vanity Fair did a story on it. Spielberg got a copy of it. He's a huge fan of it. Now they're going to make a movie of the boys who made a movie of the thing. And it seems to me that there's this kind of underground culture of people who remake movies, and their skill is in seeing if they can pull off the shot, that kind of thing.
This is the whole issue of like fan fiction in general.
Yeah.
And there's a
How
big,
is that implicated by music, or is it at all? Or is
It
this
is.
simply a recording thing?
well, for music, of course, for movies, there's a third thing that we didn't talk about, which is synchronization licenses, which are, if you want to use license in music for a film, those are all voluntarily negotiated licenses. There's no such thing as a compulsory license for a synchronization license in a film. So first of all, if you want to use the music in the film that you're making, you have to worry about the music piece. If you want to, you're taking your own shots, but the question would be, what are you taking that would be copyrighted out of that movie?
The story.
The
The
story.
storyboard. The point
The
is
dialogue.
to remake the exact movie, but do it in a way that's amateur, but as good as you could do with a handheld
Right,
video.
so a movie is an audio-visual work that has copyright protection, so, depending on what you're doing, how much you're taking, and how much of it could be seen to be fair use, you are in difficulty probably under copyright and taking risks that you may or may not be able to mitigate. Although there's always a practical question for copyright. are people going to sue you in practice for doing something like this, or are they going to view this as homage to their work?
Well, that's the
and
way
like
he
it,
sees it. It helps his movie because it became this cult thing
Right.
to see the remade movie.
And that's always one of the issues.
Own the copyright.
Right, there's also questions about who owns,
Spielberg.
there's very big questions about who owns copyright in a movie. And this is another issue where a movie, usually with music, you only have, a couple of authors or not too many authors. But with films, if you think about it, there's, look at all those credits at the end of a film. There's hundreds of people involved in a movie. Who gets copyright, right? And usually it's only a handful of people on the movie too. But yeah, it could be, you'd have to look at who owns copyright in that film to know who could potentially sue over, copyright infringement in your film. And it's, there might be ways that you could make your film less of a risk by trying to think about what was copyrighted, but it doesn't sound like that's the reason they're doing this. They're trying to make a perfect copy that's more amateur.
And it's become a thing to do now. Like you said, fan films where they try to recreate the movie.
There's a lot of issues like this also where people are making, doing the endings to novels and this is an area of copyright that's, there's a woman named Rebecca Tushnet at Georgetown who's written articles about fan fiction, and it's...
What do you mean by fan? You mean like...
I mean,
not the kind of thing like where you, who was the woman who did the, Jane Eyre, but from the Wiser Gas of Sea, that kind of homage. You finish the movie out with another plot, or Rosencrantz and Guildenstern Dead, that kind of thing, where you take some aspect of it and you write it off in another angle, or do it from Mr. Darcy's point of view, or something
Yes,
like
that kind of thing, where you're using a different character, or you're actually, finishing the story, or doing another, and what you're doing is creating an unauthorized derivative work. And the question is, if it's the extent that you're using a copyrighted work or making a derivative work based on, those are two different rights that you could potentially violate because of the derivative work market, that the owner of that work should, in the eyes of the copyright law, have the right to create their own sequel, and you're usurping that right. But, Rebecca Tushnet, I guess, has pointed out, are you really usurping that because you're doing something that is more amateurish and more different, and there's probably room in the market for both, But the idea with parody is they said parody is not usurping a market because nobody's going to parody their own work,
That's true. Please.
This is all fascinating, and I'm wondering, as a practical matter, when someone goes into practice in copyright law, do people do subspecialties in copywriting? Because keeping up with all the technology and the issues that you guys have touched on today, how is that possible?
Many people, when they go to in-house jobs, work for a particular so-called copyright industry. So you might work in-house as the lawyer for a book publishing company, or a music publishing company, or you might work for ASCAP, one of these collection agencies that collects public performance royalties, as a lawyer. If you're a litigator, you might very well get almost any kind of copyright case that came up, and oftentimes not just copyright, because that's usually seen as kind of the smallest in a litigation group, and so you might have to, even if you are the copyright person, you might have to pinch it doing some trademark law as well, or maybe even some patent litigation. You might have less control, even though they will tend to have certain clients, who come to them, and those clients might be in a certain industry or something like that. But I think the digital issues are kind of across the board, something that everyone's dealing with and struggling with. And we definitely have a problem with judges who don't understand, we have judges deciding about the copyrightability of software without really understanding how software works or how it's coded. Because software is viewed as copyrightable as a literary work, which is kind of bizarre, that's a problem, I think. But increasingly, I think you guys are really familiar, you students who are here, you don't have too many issues with digital technology, right? I mean, how many of you are deeply uncomfortable with digital technology? And if I were to ask people who were, a little bit older sitting in the room, you might say, well, sometimes I find it hard. And if you were to poll people of, say, my parents' generation, they would say, it's impossible, we can't deal with it. But the world is forcing us to deal with it. How do we check our bank statements? So that's sort of where the judges are, maybe, some of them, and some of them are in the middle group, and they're not yet in the bottom group where you guys are, where you're kind of digital natives, as it were. So I think it's easier, but it's very hard to think, even if you understand the issues, it's very hard to think about how to apply a law that was written in the 1970s to deal with, these new technologies.
Or to draft a contract going forward, even if you're very familiar with the technology now, the technology will continue to change, and so how do you protect, I don't know if that's what.
Right, what will we do when we have, I was reading somewhere about, translations are derivative works. So what happens when people have, chips implanted in their brain that allow translations? Google Translate is in your brain. If you go to another country, then you can just read whatever is there. How is that dealt with as a matter of copyright? Not easy. If we agree that it's going to happen, or might happen going forward.
In some of these theories like migrate, I know this guy he got fired, he's teaching creative writing, and he wrote this novel, he won Fanny O'Connor award for the short story, and they were getting ready to give him the prize. They were having it proofread, because he gets published in this thing, and they were having it proofread by this lady who was of an older generation, and she was reading, she said, I've read this before. She goes and picks up this novel from 1920, and he is placed 20 pages right from him in there. And she said, you're a plagiarist. And he said, I was only sampling this work. That's all I was doing. And he said, everybody knows that work. She said, nobody knew that work but me. And so this big argument, of course, the Atlanta Copper people, they said, you're fired. Well, we're taking this prize away. And he got fired. He's in Czechoslovakia teaching composition.
Maybe sampling could be a past lawful plagiarism.
Well, sampling is supposed to be very small amounts of things, so I think sampling 20 pages is a little bit pushing the idea of sampling.
I'm going to have to stop us because Debbie has to get her award. Debbie's the first one that we have the award for. The first one, it didn't come in in time. The second one got lost on the UPS truck. But the third is Debbie's, and thank you very much, Debbie, for a great presentation, Suzanna as well.
Thank you.
Thank you all. All right, come back next year, we'll do 3 more. Thank you again.
She deserves it.